Yes, we will absolutely make that commitment. And we would also ask for a commitment from the city council to allow us to continue going forward to investigate and work diligently towards preserving this building. But yes, we will secure the building if given that opportunity.
Thank you, Ms. Kendrick. Thank you, Councilor.
Okay.
Appreciate you.
Councilman. Okay, can I say something?
Yes, ma'am.
Yes.
And according to the building, I've had down at the police department to put placards, do not enter, no trespassing. So if you have people that's coming in and say, I'm going to come in here, that's not my problem. You read the sign that said, do not enter. You're entering at your own risk. Now, if I board up, which I board up all the time, they'll come through and they're on board, and then I'm out of pocket of money, I'll go back and board it up again. But it surely states around the building, no trespassing. And I have a neighbor that stays across the street in the brown building there. And when things go wrong, he calls me. I say, call the police first and then call me second, because I will be there. So since they've put up the new signs around there, and I put the gate up so that they wouldn't enter on the North Staples side, I haven't had any complaints at all. Thank you.
Okay, thank you, Ms. Kimbrick. Councilman Pesley?
Okay, just a couple of things. And Matt, I want to go back and reiterate something I said last time when you make the comment that nobody's complained about this. This council has had as one of its goals over the last 3 or 4 years to encourage code enforcement to go around the city and clean up some of these abandoned buildings that have, been complaints of citizens living here for a very long time. So this isn't just about complaints from citizens. This is about making our city more attractive. Let me ask you something. I'll offer something here and see where this goes. Would your client be willing to provide a structural engineering study to this council within a 60-day period of time that tells us where you are with respect to the structural integrity of this building? I mean, from a real structural engineering firm that can go in and delineate where you are exactly, because it's exactly what we did with the old courthouse. And it's been done twice. I did it once while I was there, and they did it once after I left, and the 2 engineering reports are almost the same. But that tells you where you are in a big hurry, to where they're not spending money on fixing any part of it is going to be within reasonable bounds.
Yes, she'll provide that.
Okay.
And to be clear, it was a structural engineer who did it before, and she's correct, it was a visual inspection report, but that was a licensed structural engineer. So if
this
we need
needs
a
to be more
structural
than
engineer
visual.
report,
This
we can do it.
needs to be where they go in and they analyze the structure of this building from top to bottom and tell you and us what the structural potential of this building is on a go-forward basis.
We can
Now,
provide.
I would support that, but I'll see if there's any other comments here by the other council.
Yeah, Councilman Hernandez and then Councilman Roy.
Okay, my father-in-law grew up a block away from this building, just down Ramirez Street. Their house was torn down, and they built an apartment complex. The apartment complex has been torn down and is now just kind of a vacant lot with some slabs. I give that in reference point that, we do have, my family has roots in this area. But, and Mr. Manning, I have to give you compliments almost to the suspension of disbelief with some of your comments there with regards to this building. This is, the building is really, we have asked, requested for buildings be torn down that were in better shape than this building. And, regardless of what we're trying to do and what kind of historical significance it is, it's not safe, and it's going to cost you a lot more to try and fix this than it would be to rebuild it. I'd almost want to save you the expense of that structural analysis, because I know some structural engineers are not cheap, right? Good friend of mine's a structural engineer. He's not cheap. So, you know, this is realistically, safety-wise, Councilman Pusley touched on it, what our instructions that we have been giving to code enforcement about these kind of buildings. And it's not just your building, or ma'am, it's not just your building. We're looking at a lot of these things. We just tore one down that caught on fire on North Beach not too long ago. So I want to say that it'd be very difficult for me to vote to save this building, considering the condition it's in and the opportunity that you had to actually try and save this beforehand. So thank you.
And to be clear, we appreciate that perspective. We understand where you're coming from and why you have to come from where you're coming from. I mean, I'll say that full stop. But one, I'm an advocate, so when I'm standing next to a client, it's 10 toes down until the wheels fall off, number one. And number two, as a former prosecutor, as you know me, I would put forward a case when I had evidence after it was investigated. And I would submit to you that right now we might be at the early grand jury process. Maybe the police think there's something there, but nobody's been indicted, and we're surely not at trial. And I'd ask for the opportunity to fully investigate so we can have not only this case looked at really in earnest, but really see whether, from a cost-benefit analysis, there is some path forward for Ms. Tryon Cambrick to preserve this building, because there's no question that this building is of inestimable value to this community. But if it is one that has to be knocked down after that investigation, then we may have to deal with that at that point. But we'd ask for at least the 60 days to get that structural engineering report, to give the city council all the information it needs to make a responsible decision.
Thank you. Councilman Roy.
I just want to make a comment and then kind of expound on to what Councilman Pusley said. So I know, Councilor, that you said that there didn't appear to be an issue or anything like that in the past because the area is somewhat vacant. However, the owner, you've stated that you've had to actually go in and board that property up and keep boarding the property up. You put trespassing signs because people were trespassing, so that tells me there is a risk there, right? And you've had to go in there and make sure your property's boarded up. You also alluded to the fact that your neighbor across the street kind of keeps an eye on the place for you, and that in the past, you've actually had to call law enforcement to help them rectify a situation with people being in there, whatever the case. And I did go out twice and look at this structure and building also, and to me, a lot of the items that were laying around there, I kind of looked in windows and looked up, but it looks to me like items there are somewhat new compared, they're certainly not 20 years old. But with that, kind of going along with what Councilman Pusley said, that security and Councilmember Barrera said is important. You have a fence, it's a partial fence, it looks like from what code enforcement's saying, and when I went out there, I could see that you could get up there. That would need to be improved. For that, I don't want to give 60 days. I think that's important. I mean, because the law of probability, it said when you sit there like we're talking about this now, luck would have it that in 2 weeks somebody gets hurt, or and I know we're going to have weather. We had strong winds last night. But I would like to see, if we're even going to remotely, if we're going to agree with this, I would like to see that structure, a fence around it immediately. I'm talking within, and it would meet code enforcement's standards, but I'm talking about immediately, within 2 weeks, if possible. Because I think that's reasonable. I don't know how long it takes to get somebody to continue to put the fence up there. There is partial fence, right?
Yes, there's on the back side of the structure, there is a fence back
Yeah.
Drone footage here, that doesn't seem to be
Yeah, I
one
see
in the
that.
back.
Yeah.
right
Doesn't
under
appear
that-
to be one in the back.
And do you own the building behind it, the little building? Is that
And
yours?
your house, no,
Yeah,
that's
that's not
Bruce and
yours.
somebody's, they stole that.
Okay.
That's not-
But anyway, that's just my thoughts.
Right under there where that pillar on, well, can you see? I mean, from the fence over here to there is a wire fence. There is a wire fence.
Just for clarification, Councilman Roy, would be saying essentially that you would want a fence around the entire perimeter,
I would
including
want
the
it-
front?
I want it secured, and whoever makes that decision, whether it's you're working with code enforcement or just a fencing company, somebody needs to make sure it's secure. But the other thing is that if that's the case, if these things don't happen within that period of time, then I would just suggest to council that we have the ability to go ahead then and say, we'll demolish this. I don't see that, right now, we're taking up a lot of time, and I think it's an important issue. But I think that if something happened in the future and these things weren't met, unfortunately, because there is a history of 20 years of things, where we've had to table this and it hasn't been met.
I don't know that due process would allow you to do that. I mean, I think at the very least, the ordinance provides due process, so we could at least file a subsequent appeal if that was appropriate. But if you're saying that the city council should be able to put a note in that if we don't meet this condition, it's automatically demolished, I don't know that that would afford her due process rights as written in the ordinance, unless there's something that I'm unaware of. And maybe the city attorney can provide guidance on that.
Are you wishing to modify the
No, I'm
resolution
not
so
at
that
the
it
point where I
automatically
wanna
becomes
modify that, but I want
effective and
you
the
to answer
order is
the question.
automatically effective at such time as she fails to comply with the condition? We've done that before if necessary.
Okay, go ahead, Mike.
I think,
I'm so sorry, Councilman Pusley, we had one more comment.
Okay,
Just
I'm
real
sorry.
quick, my chance to make a comment. I support a lot of the comments that have been made. To Councilman Roy's point about securing the facility, if we are going to allow some additional time, whoever's going to craft whatever resolution we address here, is the signage, like Ms. Cantu pointed out, the signage looks like it's directly over the sidewalk. So that's concerning if that signage looks like it's bowing and could fall off the building. And then secondly is the pieces of tin that are flying to the neighboring properties. This is not a good time of the year with these northers blowing through to have tin flying around. So I think if we are going to come up with a solution that's going to provide some additional time, that the securing of this building include addressing the signage and addressing the flying tin.
Yeah, go ahead.
Okay, I'm going to make a motion that we support the staff's recommendation in the Building Standard Board to demolish the building.
Second.
You're going to support, I'm so sorry, you're going to motion to move forward? Okay. We had been talking about giving them the 60 days, which you had mentioned.
Yeah, I just think, I just think that we're going to be back here in 60 days, we're going to be fighting this same issue again and arguing about whether or not we think this is going to work. And I don't think, we boarded the old courthouse up all the way to the second floor, and they took a steel pipe and beat a hole through the brick wall on the first floor. So I don't think, when people want to get into these old buildings that are abandoned, they'll get in them. They'll figure out a way. They're very clever, and I don't think a hurricane fence will stop them if a brick wall won't. And again, I just think that,
If I may, Councilman, the the DA's office prosecutes burglaries every day where
Yeah.
people have come into houses that are well secured.
And you know what, Mr. Manning, that aside, and I respect that, but I think that the board is meeting, you said. The Historical Commission is meeting. They have made, obviously, they care about this, and I'm interested to see what they do have to say about it. I do believe, let's put everything aside, historical or not, or where it is, just put everything aside. There's a public issue, a public safety issue, and that has to be addressed. And I think those were the last comments you heard. So for me, if those can be addressed immediately, go see what the board has to say. And then, if funding, my business is not your finances. So I'm not going to sit here and ask you, how do you plan on paying for this? Or that's your business. But there is going to obviously be, it seems, and I'm not a historic preservationist, but a huge cost involved in this. And I understand, you mentioned, Mr. Manning, there could be other avenues. that you might need time to find, right, those funding mechanisms for, which I respect. But I think initially for me, I'm okay with the 60 days, with that report coming back, and with public safety issues being addressed immediately. And then we move forward. Like you said, it very well can be, you know what, this is going to cost way too much. The Historic Preservation Committee said this. It's going to be based, in my opinion, on what they might have to say this evening. So that's where I stand. But you did make a motion, Councilman.
And it
we
was
can.
seconded by,
And it was seconded, exactly. So we can go ahead and call, is there any further discussion? And the motion is the original, to move forward with demolishing. Okay, Ms. Huerta? Or all in favor, say aye.
Aye.
Any opposed, say no?
No.
No. So the noes were Councilman Hunter, myself, Councilman Barrera, and Councilman Klein. And Councilwoman Campos, I'm sorry. Now, would you like to make a motion? Or,
Okay, so it fails,
Move
right? The
forward.
resolution failed?
I didn't vote.
correct,
Oh, you
I
did
sat
it?
here and listened. I did not give my vote. I
okay.
didn't say yes, I didn't say no.
Are you going
I'm
to?
just,
So you abstained?
what's that?
You abstained?
No,
Or-
I'm not abstaining. I
Okay.
just was sitting here thinking. and
Oh,
everybody
okay.
jumped really quick, and I apologize. This is a tough decision. It's my district. There is a lot of historical
Right.
consideration there. But the only way I would consider it is the fact that, as I stated, and as what Councilman Suckley stated, is to secure it immediately. When I say immediately, we need to give a date to that.
Yes, I agree.
And with the provision, which Miles said we can do, that if it fails to happen,
Right.
that we go ahead and demolish it. I don't think we should take up the council's time
I agree.
if those things aren't met.
I agree. And I think you can, well,
So with that, I'd like to say, I'd like to vote no against the current,
okay.
but I'd like to modify it based on what you just said.
Well, it failed, so you have to present something else.
Pardon?
Right, because the resolution
make a
failed.
motion.
Yeah, make a motion. Make a new motion.
So if I understand this, I'd like to make a motion that, and I'm going to ask for council's advice on this. I said 14 days to secure it. What's reasonable?
14 days.
14, Mr. Meaning's
That's
saying
what I-
14 days.
That's what I figured you would say, 14 days.
Yeah.
Be
Okay,
amenable to that.
so to secure the site within 14 days, within 60 days, have your a full structural engineering report done. And if those things fail to happen, which Miles said, we can have the ability to just go ahead at that point in time. And if those things fail to happen, then go ahead and demolish the building.
We'd vote in favor of that motion.
And Councilman and Mayor, for the record, just so the staff can follow through with the council's direction here, securing is what, a perimeter fence?
I say securing it to make sure code compliance, you have the expertise in making sure structures are secure.
We
So
should lay it out here so we know, but so the applicant knows and we know. Are we talking about an 8-foot fence, a 6-foot fence around the entire perimeter?
what is currently there now?
Tracy, can you
And
tell
what would
Tracy?
be the
for rest-
recommendation?
think
What would be the
securing?
recommendation?
Let Tracy speak, please. Go to the microphone. Yeah.
So the board ordered a perimeter fence to be placed around the building, in which that wasn't complied with, but it is typically a 6-foot-high fence is sufficient. 8 feet is difficult to come by, but a 6-foot-high fence that would secure that. But also, in addition to that, that upper floor, the door is open. And with the fencing that's there currently, there is a gap in the fence along the back side of the building. But, so there is not a complete perimeter fence around that building. There is space to access that.
So we need a 6-foot
Yes.
perimeter fence
Yes.
securing
And the-
completely.
And
securing.
access boarded up so you can't get upstairs.
Yes, sir.
Yeah.
It's got to meet your expectation, is
Yes.
what I'm saying.
Yeah, because
Yes,
they'll
it would.
just use the 6-foot fence as a ladder.
They would, but, and.
To climb up to the second
It does
floor to
have,
get
what
in.
she has, it does have some razor wire on it, but again, it's not a complete fence around. 8 foot would be better as it is a higher fence. However, regardless of that fence being around it, the openings are still unsecured.
But the
And
openings
so
have to be secured.
The openings would
Okay.
need to be secured.
So
And
all openings would be secured, Tracy? The windows, the
Yes.
doors?
At any point of access, I mean, right now, person couldn't get to the second floor through the window, and you've got a considerable gap in the wall because of the collapse of the roof, so that's not necessarily feasible, but there is a staircase from,
Right.
leading to that second floor.
That needs to be.
Okay,
You
so
know, that
secure
needs
the
to be
staircase completely
Yes.
so you can't climb up it, and close all the bottom openings, and completely surround the building with a 6-foot fence.
Yes.
Including on the sidewalk or the front of the building?
Yeah, I believe so, because again, you've got that marquee sign, if that's not
including on the
removed, you've
sidewalk.
got that will likely fall at some
So you'll have
point
to
down
get
onto
sidewalk
the.
permits
Yes.
to put a fence in the sidewalk.
So that
That'll have to be
right
done
away,
through
that
the city.
sidewalk needs to be fenced
Right.
all the way, from the curb around the perimeter to completely
Okay,
secure it
including
on the first floor
sidewalk.
and second
We just
floor.
want to be clear, because, so we have to know what to follow here.
I think that's good, and then also the structural engineering report within 60 days, and if that's
Yeah.
failed to be obtained, then that gives the city the right to tear the building down.
If I could,
Did you say it's 14 days, though, to do that?
14 days for the securing of
For
the,
the securing,
starting
correct?
day one's
And
tomorrow.
then 60 days for the report.
60 days is for the structural engineering report.
And Mr. Suckley had mentioned signage and flying tin. Is that included in that, too?
It wasn't in the motion to remove the marquee signage. The fencing around the sidewalk will prohibit people walking next to the sign that's about to fall off. So 6-foot fence, secure all the openings, secure the
Ground floor.
stairwell so you can't go up to the second floor.
Yes, sir.
And then that's 14 days, day one's tomorrow, and includes the weekends and holidays.
Yes, 14.
And 60
consecutive
days also starts tomorrow, and that includes the weekends and holidays and any other day.
Yes, sir.
Okay? Is that the motion, Councilman?
That's the motion.
Great.
Clarification first.
Yes, you may.
Can we have a provisional approval then of all the permitting and everything that we'll need? Because if it's going to take longer than 14 days.
You
we
got to
don't
go
want
through
be
the
in that
sidewalk
situation.
closure process. That's within the 14 days.
Okay, so can we have some kind of statement from you or from the council directing
that's
them to
done
give
through-
us
Well,
that?
you have to
permission?
get a
That's
permit
done, that's done through Development Services.
Yeah.
That's delegated to Development
So
Services.
can they
That's
be
not a city
instructed
council
to make sure we
function.
have what we need to get where we
You
need?
talk to
Yes.
them. It's in the
Yes.
14 days, yeah.
They're watching,
They're
Mr.
listening.
Manning.
Okay.
Yeah, they're open today and tomorrow. Yeah, they're open the rest of the week.
Okay, so you have a,
So we have a motion, do I have a second?
I'll second that, but Councilman Hernandez has a comment?
Mr. Manning, in looking at this, and I asked you to advise your client that, I would also, because you're going to have an expense associated with this. And
Right.
I'll go ahead and support what's happening here. I don't think it's the most economical thing to do. But if it does happen, I'd also suggest that you look at what it would cost to demolish this facility yourself under your own contracting, because it might be cheaper than what we do.
Okay.
So
I appreciate that.
Just, you may determine later on that it's just not worth it. But I would, at least look into that to where you can actually save some money on the demolition.
We will, I appreciate that.
Thank you.
Okay, we have a motion, we have a second. All in favor, say aye.
Aye.
Any opposed, say no. The motion carries. Thank you, Ms. Cantu and Ms. Kimbrick. Let's see here.
Excuse me, I know you ended this, but the picture that shows there, I know I bought the property in resale, tax resale, but there was a windstorm in '22, and that was caused the roof to fall. It hadn't been way back in 20 years ago. It's just been 2 years ago.
Okay, thank you for that
Okay.
clarification, Ms.
Thank you.
Kimbrick. Okay, we are going to, let's see here, well, it's 1:36, and Ernie's already at the podium.
I'm sorry.
Did he
We're
bring
not
lunch?
going to
Did he bring lunch?
Did you bring lunch?
Did he bring lunch or snacks?
Yeah, I was going to go ahead and break for lunch. We're going to break, I know, I'm sorry, who just did that? We're going to break for lunch, and we will be back, starting with item number 4, and then number 5, 8, and 11. Let's see, do we have a, yes, we're going to go into executive session on item number 24 per Texas Government Code, Section 551.071 and 551.087. We will return.
Yeah. Awesome. Thank you.
Let's see. Okay, we're going to go ahead and reconvene our meeting and pick up where we left off, which is item number 4, which is an ordinance amending the Corpus Christi Code to amend Chapter 49 Streets and Sidewalks and Chapter 53 Traffic regarding requirements for performing work in the public right-of-way and placement of utilities, providing for properly restoring street surfaces that have been cut for utilities or other tie-ins.
Okay. Good afternoon, Mayor, Council. Ernie De La Garza, Director of Public Works. Happy New Year. This ordinance was tabled last time, and then we're bringing it again. But before I go into the presentation, we did have some feedback that led to us pausing the ordinance and then coming back, and then we put it in the memo. But real quick, I would like to give you some high-level background as to how we first delivered this ordinance to industry. And I'll give you the timeline real quick, and then we can get into the presentation. But on September 15th, when we first got the first draft of the ordinance, Public Works presented this ordinance to Development Services Task Force. We also got in attendance was the Coastal Bend Home Builders Association. They asked for a comment period, and then we did give them that comment period. The presentation was emailed the same day to over 150 contacts on the task force distribution list, which included, again, the Coastal Bend Home Builders Association, in addition to all the other users in the right-of-way. On September 28th, Public Works emailed the Coastal Bend Home Builders Association we emailed them to coordinate a meeting to discuss the ordinance and then also have an opportunity for them to provide comments. On November 7th, Public Works met with the Coastal Bend Home Builders Association on site. Of that meeting, 8 were present, 5 were city staff, and at that meeting, we received no objections presented. They did discuss the design standards for curb and gutter, but we never received anything in writing as an official response from them in opposition to this ordinance. And I understand since then that there has been that opposition, but I have nothing in writing. And so, for example, the rapid pavement program, when we rolled it out and there was something that industry pushed back on right away, I received calls from Anderson and Columbia. I also received calls from Bay and any other contractors that might have had issues with what we were presenting, and then we made adjustments based on that feedback. I was never afforded written documentation from the Coastal Bend Home Builders Association that was very specific to the draft ordinance that we presented. Now, granted, they might have circumvented Public Works and sent that feedback by other means, but I never received anything. Otherwise, we would have acted on that feedback and made any adjustments that were necessary. But that being said, that doesn't mean that there aren't avenues in the existing ordinance as it is presented today to work within the confines of this document so that we can compromise or quell any type of disagreements to the ordinance. In addition to that, one of the key things that we have brought up when we were speaking to Councilman Hernandez about the appeals process, which is what led to today's presentation, was that our position or our recommendation was specifically based on the protection of the public health, safety, and welfare, because the big difference between the right-of-way permitting process and then what you have at DSD is that Development Services usually deals with private property, but once you go into the right-of-way permits, you're dealing on the public domain, and it's all public right-of-way. So traffic control plans, use of a plate over a trench, the way a contractor will leave the road after they're finished with the work, and is it a flex-based surface or a hot mix surface or a good repair? All those things are things that we consider when we're dealing in the right-of-way. In addition to that, it's multifaceted, many users in the right-of-way. So we have contractors, consultants, private owners, business owners, development community, and just to name a few. And so we're coordinating through that entire realm. And so some of this feedback that I have received to date, what I've received as far as concerns about this ordinance is really a small part of a bigger picture of what we have to responsibly administer as far as this right-of-way program. So in addition to that, we have also established workflows from scratch. As you recall, our team, it used to be Development Services, now Public Works is handling this program, and so we have developed from scratch workflows that did not exist before it was transferred to Public Works. And so as part of the budget initiative, we did hire the staff that was necessary to manage the right-of-way, and then we've also, through your just recent consent agenda, you've approved a software package that we are going to use to manage this whole ordinance online rather than using email and websites. So with that, we can get to the presentation. I know we've presented this to entire staff. If you want me to represent, I can.
Yeah.
And then I'll have Renee come back up and present this. Okay.
Good afternoon, Mayor and Council. Renee Couture, Assistant Director of Public Works. As Ernie stated, we're here to present our ordinance updates to Chapter 49 and 53. Next slide. The purpose of these ordinance updates is to update our policies and ordinances regarding our right-of-way management for basically construction-related activities. We're also in the process, this ordinance updates our street cut utility requirements. We are recommending a repeal of Chapter 53 as it would conflict with the language we have proposed in Chapter 49. Next slide. These updates were needed. As you can see on this slide, that it indicates that in Chapter 49, it demonstrates different departments, some that are no longer in existence, responsible for management of construction activities like driveways, sidewalks within the city right-of-way. So the Director of Engineering and Physical Development, that was from an ordinance from 1958. Right now, the ordinance puts the authority to administer street cuts under the Director of Development Services. Next slide. With regards to the street cut policy or ordinance itself, we originally, as a city, adopted an ordinance in 2013 for street cuts. Since that time, with some of the issues that we've noticed and improvements that we'd like to make to become current with best practices, we are recommended changes to what is shown in our ordinance for newly constructed streets. So basically right now, any street that is considered new is a street that has been resurfaced or maintained within the previous 5 or 7 years, depending on the classification of the street. Any street with a PCI over 85 is also classified as a new street. In order to cut into that street to perform any type of excavation work, you would need a variance from the director. The director specifies what the restoration requirements are. Those are issues that we've noticed where, due to the ambiguity or uncertainty of what those restoration requirements are, we've received numerous questions. So it's one of the reasons why we're proposing in the ordinance, you'll see in the next few slides, what those recommendations are for restoration of new streets. The ordinance does provide provisions for cuts on streets that we'd normally permit, regardless if the cut is parallel, perpendicular, or if you're performing a cut on a concrete street. Next slide. So over the next few slides, we've provided different patches or cuts that we've experienced in various districts. What we're trying to provide in this ordinance update is a uniform method of restoration, especially on our new streets. Next slide. You can see that there are inconsistencies in the repair types. At times, we do experience contractors not even coming to the city to even obtain a permit. But when they do, even if they follow the current procedures, what we find, like I said, is a lack of uniformity or inconsistency in how the street is repaired. Next slide. So as you can see, like in the middle picture here, that parallel cut, what we require per ordinance right now is just a 12-foot patch. These are some of the improvements that we're trying to make, especially on our newer streets. Especially, like I said, especially on our newer streets. Next slide. So the overall goals that we'd like to achieve with these updates is, of course, updating the definition of a new street. I'll get into the specifics of that in a second. Updating our street repair specs, reducing infrastructure damage. The more we cut the street, the more potential there is to reduce the overall structural strength of that street. We'd like to increase the safety and convenience for the traveling public, and of course, designate the director of the Public Works as the official to administer ordinances for management of right-of-way activities and for street cuts in the city. Next slide. So on the left, you'll see in a light pink area are what our existing ordinances, what our existing ordinance says with respect to new streets, the restoration requirements for flexible pavements and rigid pavements being concrete. What is shown on the right in green are recommendations for streets based on the age. So we are proposing to define a new street as any street that's been resurfaced within the previous 7 years, regardless of the classification, and a street with a PCI of 70 or greater. Now, as far as the restoration requirements, the 3-inch overlay, that's in our current specs, so that really doesn't change. What changes is that any street between the age of 0 to 7 or a PCI of 70 or above is they're going to require curb-to-curb restoration. The width will differ depending on the classification of that street. So if you touch a street, or if you propose to cut a street that has been resurfaced or restored within the previous 2 years, we are recommending curb-to-curb on the width, and then from block to block, basically giving us a new street because we just invested and paid costs for the maintenance and reconstruction of that street. We're lowering the PCI requirements. And with the rapid pavement program and some of the maintenance that we're doing, the PCIs are expected to be above 70 when we're finished with that maintenance. If you're planning to cut or excavate a street between 2 and 7 years and it's an arterial collector, it's still curb to curb, but the width, or actually the length, will be 25 feet beyond the edge of excavation. Point of note, this particular recommendation is basically the variance requirement that we're handing out as we speak to anyone that comes and touches the street. So if someone, the ordinance allows the director to make a decision, and so this recommendation is a recommendation that we are handing out today as we speak. So we're basically formalizing a recommendation that Public Works provides to anyone cutting a new street. For residential streets, we are maintaining just a 10-foot from the edge of excavation on either side. Next slide. So these next few slides basically provide graphical representations of what we're trying to recommend. So for a new street between 0 and 2 years and a PCI of 70 or above, you'll see it's curb to curb and from block to block. Next slide. If you have a street section sort of like Oso Parkway or Yorktown or Ocean Drive with the median, you would just be responsible for restoration on the same side of the median where the cut occurred. Next slide. This is a graphical representation for the edge of excavation, 25 feet on either side for a street between 2 and 7 and a PCI of 70 or above. Next slide. It's basically a repeat of the previous slide, but showing in a residential street, the difference is 10 feet instead of 25. Next slide. And this is basically any street that is considered an older street, PCI of less than 70, or it's aged out, greater than where there's no maintenance in the preceding 7 years, or PCI below 70. You're just responsible for the full lane and 10 feet beyond the edge of excavation on each side. Next slide. So staff is recommending these approved amendments, revisions to the existing ordinances as presented, where basically highlights where designating the Department of Public Works and the Director to administer right-of-way management activities and the street cut permits. We are also seeking to repeal Section 53-195, as it will conflict with proposed changes in Section 49. As Ernie noted, we did meet with Councilmember Hernandez to discuss some of the concerns that we had. We are maintaining the ordinance language as originally proposed when we presented in December. With that, it's the end of my report, and I stand by Ernie and I for any questions.
Any questions, Councilman Hernandez?
Okay, I see that you did not include the language for appeals process to the city council. The reason I asked, I actually originally asked for the Building Standards Board, but I misspoke on that one. It was really should have been the Construction Trade Advisory and Appeals Board, because they have somewhat of a judicial aspect to them. But after discussions with the attorney, they said that that was not possible because it was in, I guess, the right-of-way or public property, which I don't quite understand, because, I mean, we give Development Services gives permits to school districts that's public property. So, I don't know, that seems kind of odd. All that being said, I didn't want to leave full authority with staff and delegate our authority as a council completely to staff. And it's not to say that you're a bad person or, you know, you're not trustable. It's more to say that you're not going to always be in that position. We can have another Mark Van Vleck, right, that is in that position that may not have that kind of professionalism that you exhibit. So I want to make sure that there is some appeals process to the council to address those issues that may be not technical, may be other issues, may be something that doesn't fall within the actual description of what you have here. So it has less to do with the staff's capability and more to ensure that we don't legislate tyranny. So I will be offering up an amendment. Miles, did you have that amendment recommendation?
If I may, sir, to respond, we did meet and yes, you did present that and we did review that. And you're correct. Like I said, when we work in the right-of-way, there are many situations, instances that develop. The ones that you mentioned that are not technical, for sure, those ones could very well be appealed, and then this body could make those decisions. Not that you cannot make the technical decisions, you're all very bright individuals and you can, but the situations that we are really referring to, like I mentioned to you at our meeting, is we have had situations where we are on an arterial roadway, and then somebody's seeking a permit, they give us a traffic control plan, and we deem it not compliant to the Texas Manual of Uniform Traffic Control Devices. In that case, we would tell the individual or the contractor seeking permit the reasons why we are not going to grant that permit. And it could be a number of things. It could be because the taper lengths don't meet the speed, or the turning radii are not good for the trucks in the area, and it could be a safety concern. A number of reasons why we would reject the permit as is. And then in that situation, we bring the individuals in, the contractor, and then we explain what we need, we compromise, and then we get what's needed, and then we give them the permit. In the extreme case where a permit applicant will come to council and say, well, I just disagree with your findings as licensed professionals and professional engineers. In addition to that, we are going to incur costs that we don't feel is necessary for the work at hand. And if they don't have a professional on their side, a professional licensed engineer, well, then we'll say, okay, well, unfortunately, one, we're following the Texas Engineering Practice Act, and in addition to that, we're also following city ordinance and rules and regulations, and that's how we base our findings. In that situation, if it does get appealed to this body, then we are also twofold working with legal to try to manage the risk to the city as a whole so that something unsafe doesn't get done and then we don't take ownership for something that not only is not compliant to the Texas Manual Uniform Traffic Control Devices, but also covering the risk to the city legally. And so that's one situation that carries over. Another one could be improper use of trench protection for the workers in a trench. And we can go on and on. But like you said, if somebody pushes back and they say, well, I just don't feel that's necessary because they may or may not know what I'm talking about because they don't have a professional on their side of business, then of course they'll appeal if that's an avenue available to them. But in that case, we feel that we expect to get hundreds of these permits coming in. So you can imagine if you have a number of those getting appealed, that then you'll be similar to, I guess, the presentation before. That situation will kind of repeat itself, but in terms of right-of-way permit appeals, so on and so forth, well then, we'll be here over and over again. So that was the thought. It wasn't really to shoot down your idea or anything. It does have merit in some situations where correct, if you have a city employee who's abusive with their authority and they don't do what's correct, then yeah, you could very well have that case and they would abuse their powers with this type of ordinance. But like I mentioned before, we Public Works, we do pride ourselves in being a partner with the industry, contractors, also private landowners and so on and so forth. And I get the fact that you're saying, well, we might not be here. We're trying to build a culture that would repeat itself, hopefully, beyond me and anybody else after me. And, that's the best defense I can give you is that we're building that culture and we would hope that any official at the city would be upstanding, ethical with the, authority that this council has deemed to us and to other departments at the city of Corpus Christi.
Thank you.
Okay, just to respond to that, I appreciate your answer, okay, but that is not how, it's not realistic to think that there won't be somebody that abuses their authority in the future, or it is some other organization. That's why we have a council that has appeals process. That's why we had code enforcement and the appeals process there. We've had one for the Construction Advisory Board. So once it goes to there, they can appeal to council. It is part of a normal process of what we do as council, and it shouldn't be any offense to anybody in your organization or anybody in the city. There's always those situations where you need to have that legislative body where they can address their elected officials when they have a grievance. Now, the other option is that they could come to a council member. We could put three council members, put our name on an agenda and stick it on the agenda for a week, following week, and you'll have a week to prepare. I don't think that's the ideal situation. I'd rather have there be a delineated process, so it'll give you the opportunity to put your ducks in a row and prepare for that defense or that position within the city council. It not only protects the individual, but it also protects you as well and our position as a city. So I think there's a good opportunity here for us to come to a compromise and say have an additional line in the appeals process that goes to city council. And I would say 99.9% of the time, you'll never see it. We'll never see it. I've seen 2 in the 5 years I've been here for the Construction Appeals Board or Trade Advisory Board, the entire time I've been here, 2 of them. So it's not going to happen regularly. I just think in those times where you have a professional disagreement between 2 professional engineers, you need somebody to arbitrate that.
Understood. Yes, sir.
So
Thank you.
After questions, I'll be offering that amendment.
Can I just add to that, Councilman, just to point out that all those examples where it's personal property other than the city. So in this case, this is the city's property, and it's taxpayer money. In all those other cases, it's other people's property and other people's money that want that appeal process. It's just a difference.
All the more
to point
reason to
out.
have an elected body decide it.
On our property, right, taxpayer money, so it's fine. As we said, if the council wants to get in the business of doing this, you can. That last case took us a couple hours, so if the council wants to, it's your prerogative to do that. We're not recommending it, but.
That's why we get paid the big bucks, Peter,
Yes, sir.
to make those decisions,
Okay,
right?
sure.
And they're all sound.
Councilman Roy.
I want to make sure I understand something, because I'm just thinking about my district and then streets like Yorktown or something. But like on Leopard or the Northwest Boulevard, those streets are actually maintained by TxDOT, but they're within the city limits, right?
Leopard will be ours after y'all pass the,
Say that again?
Leopard is going to be a city road now that we passed the ordinance, the ordinance for Leopard to come to city. So Leopard from US 77 all the way to downtown, that's ours. Northwest Boulevard is TxDOT, and we do partner with them for right away.
So I'm just, find a street. I know there's streets out there that TxDOT is responsible for. With that, my question is that does TxDOT have to follow what you're asking?
That's a good question. They do not, sir.
So they don't.
Yeah.
So this is where I'm headed with this. Because I think about the fact that Leopard, Northwest Boulevard, I'll use that as an example. It's got that median that goes all the way through. And if I follow your recommendation here, depending on what they're repairing, they would have to do both sides on the other side of that median, right?
No, just the side of the median that's affected.
Okay, so if there's a median there, it basically just...
That cuts it off.
That cuts it off. Okay, that was one of the questions I asked. Number two, what is the probability, or how many times do you think it will occur? I mean, how many TxDOT streets that we have that are managed that, because I don't think they don't use that standard.
No, they don't.
So...
Well, to clarify, you're saying they don't have an appeals process that goes to like a public...
No, I'm saying they don't really require, they still allow patching, right?
Oh, TxDOT patching.
And they're not going to sit there and put your ordinance where you've got to take it on both sides of the street, or you've got to have a certain width and go block to block. They don't require that.
I don't recall. I wouldn't be able to speak to it. I don't have the manual in front of me to see what their process is.
I would be curious about that, because I think in terms of a developer or somebody that's coming across that, and TxDOT says, no, you can do it this way, and then we're requiring them to do another way, there could be somewhat of a conflict.
Yeah, but interesting point you bring up, that it wasn't really specific to your point, but coincidentally, I served on the District Traffic Safety Review Board. I was chairman of that board. So whenever there was a request for right-of-way use within the TxDOT right-of-way, if there was something that we wouldn't agree with, it would get appealed. So the appeals process at TxDOT did not go to an elected body. It actually went to a board that I was chairman of, and then there was a board of other engineers that were from the district that would rule on that.
Right.
And then come up with that find and say, yes or no, we find in favor of the appeal. And so, to your point, even the state government doesn't appeal to like a governing type body like this.
Right. So I was just curious about that because, TxDOT, I'm not saying that TxDOT does the bare minimum. I'm not saying that. But they have their own set of rules.
Well, coincidentally, I was the utility management coordinator. So anything that was a compensable or not compensable utility at TxDOT, I'll tell you right now that the standards that they hold are way beyond what the city holds. Okay, so you might not see it on the surface, but you'll definitely see it on the trench. And so the performance requirements, the testing requirements are all there, nothing like what the city requires. And so therein lies what we're trying to get after, is that we have issues with potential for a brand-new street to have a substandard trench, and then that would pretty much just vein out to the rest of the pavement, which we've invested in. And then, as you know, the rapid pavement program does have some limitations in funding. And so here, our number one priority, or my task that I was given when I was hired, was the residential streets and then all the other streets in the city. So really, this ordinance is just in protection of that, that order that I was charged with.
And to add real quick, and this is my last comment, is that what happens, and we've seen this, we've seen streets that are brand new, and for whatever reason, a couple weeks later, there's an issue. We had a pipe that breaks, something happens, and then it's repaired, and it's not repaired to the neighborhood's liking. We hear about that. We hear about that all the time because they go, oh my God, we just had the street, number one, what happened? And we try to explain that, and then they say, but look at this, So I get it. There's always room to improve quality, and I appreciate that.
Yes, sir.
Councilman Sackley?
Thank you, Mayor. Good job, Ernie and Renee, with the presentation and articulating your position, Ernie. You and I think, did our first ride around in March, I think, of District 4. And I brought to your attention my concern with the utility cuts. I think Flower Bluff Drive is probably the poster child for situations like this, where I think Bay had just done a brand-new overlay, and within 2 years, there were 3 bad utility cuts on that section of street. So I appreciate you being proactive to bring these revisions and amendments to the ordinance. Thank you.
Thank you, sir.
Thank you. Is there any other comments? Councilman Pusley?
Yeah, thank you, Mayor. And Ernie, thank you all very much for all the work you put in this. So I have a couple of questions. Who is this primarily going to impact? What users are going to be impacted by this new rule?
Primarily our utility owners, mainly the
Like
utility.
AEP and the
AEP. and, telephone, fiber optic. Our own internal utility department as well.
Okay. So how is this going to impact the Home Builders Association?
So we've had that discussion before. Development Services used to do the
I'm
permitting.
sorry, I'm squinting.
I'm sorry,
But these lights are shining in my eyes.
Yeah,
I can't see anything.
mainly, for what I understand to be the concern is sidewalk and driveway permits. And so my explanation to one of the concerns that was relayed to me was, if we have a brand-new subdivision being built, and they finish the street, right, and then they start building the homes, and then you have 15 driveways on one side, 15 driveways on the other side. Do we have to get everything permitted? Well, I can see that volume being a concern, and so the answer is yes, you have to permit any time that you come into city right away. But as far as the street cut, we do have standards that we can work with, where if they only cut at the edge of pavement line and they don't destroy the pavement that's brand new, well, then they can do their work at the edge of pavement and beyond and not be affected by the ordinance, not have to do a curb-to-curb, block-to-block repave, right? But it's going to require that, one, they practice due diligence with their workmanship, means and methods, and then follow the standard. But two, make sure that they take care of the asset, which gets transferred to us once they're finished with the home building, and then we become the owners of the infrastructure. But there are avenues to prevent a complete repave of every subdivision that they've just finished whenever they go and cut into the driveway or the sidewalk work.
Okay. Well, and I know you said a while ago, y'all had met with that group and apparently had not heard anything significantly back from them.
Correct.
But I got a lengthy protest communication from them this morning.
Right, I would have appreciated all protests when we actually brought them the information, but I received nothing. And so, apparently it was dead on arrival. But if they would have communicated their concerns, just like the rest of industry that I deal with for all the contracts that we put out there, I'm sure that we could have, either compromised or came up with something that would, ease their concerns. But even now, sir, without having a discussion all over again where they do bring up these issues, I do understand that their concerns are driveways and sidewalks, and I'm here pretty certain that we can come up with standards and means and methods that would eliminate that concern.
I could understand an example that you just gave. I could understand there being consternation over the fact that as a developer, I've got to go pull 30 permits to make 30 driveway cuts.
Right.
And it seems like we ought to be able to have an overlay for that, to be able to do that on a development basis.
Right, we can work within this ordinance and with legal to expedite. We're here, we're partners with industry, we're partners with private development and then also private owners. This isn't a gotcha tool. This is a tool that, one, we have processes and procedures in place for the administration of use of the right-of-way. But in addition to that, you have some kind of consistent expectations for how we do business at the city. We have to be organized, otherwise what we have today may not be too good of a tool in the toolbox.
Okay, thank you. That's all I had.
Thank you, Councilman. I'm going to go ahead and open public comment. I think we might have two people, David Loeb to make public comment, and then Alicia Casperides.
Thank you, Mayor and Council. David Loeb, 4771 Ocean Drive. I'm speaking for myself and not on behalf of the college. I'm here to offer you some context around the existing ordinance and some concerns about the new version. I was involved in passing the existing ordinance. The existing ordinance was the requirement by the majority of the council before the street fee was passed, to give you some history. The existing ordinance was written with utility connections for adjacent users primarily in mind, and the new one seems to be written with large utility companies in mind. As a result, the vast increase in bureaucracy, it's 33 pages long, will chill efforts at redevelopment by creating an entirely separate bureaucracy that citizens will have to navigate to establish or reestablish utility service. I've already seen cases where the connecting to the city line and the street is half the overall project cost. One of the reasons the existing ordinance is not working well is because the city discontinued the practice of having one-on-one meetings with adjacent landowners prior to a major street project. When those were done, one of the topics discussed was adding any expected plumbing or utility stubs to avoid the need for later cuts. So before the city did the work, they told landowners, hey, you need to do your cuts. Hence the ban on cutting new streets. With staff no longer having those pre-construction meetings, that ban has some issues in terms of providing services required by law and common moral sense. I read staff's concern about an appeal process to an advisory board, and it does have merit. I will say that if this language was included in the UDC, then the Board of Adjustment would have statutory authority to grant variances and interpret the ordinance. B of A is not advisory in nature. As someone who's familiar with the issue and on the new UDC review committee, I would be happy to work on merging the ordinance into the UDC. This would also solve the constitutional and charter issues in the ordinance before you. For instance, section 49-30 permit includes a statement that, in quote, in the event of a conflict between the UDC and IDM, the IDM will prevail. Because the IDM is not a council-passed document and can be altered by staff action, this violates numerous aspects of charter and state law and state constitution. Generally, a legislative body cannot transfer its legislative powers to staff. So I would encourage you to hold off on this and allow the committee you have assembled to review it. Staff itself, in drafting this, already recognized some issues on holding adjacent property owners to the same standards as AEP or the cable companies and created some exceptions. I think the place to start is setting up different systems for adjacent property owners and right-of-way users, so the large users have the full vigor of an ordinance like this, but property owners aren't spending tens of thousands of dollars just to get water service. In other words, it may be entirely reasonable to have AEP and AT&T be certified and do their own repairs to city spec. It's probably better for individual property owners to pay a reasonable fee and the city to do the work with city crews trained to work in the right way and not whatever pavement company they happen to hire for a very small job. Thank you.
Thank you, Mr. Loeb. Alicia Caspiridis?
Mayor, can
Yes.
we have that comment about the discrepancy in the charter between the IDM and that ordinance that Mr. Loeb just mentioned? If we can have an opinion from the attorney on that?
Yeah, we will. We Go ahead, Miles.
Yeah, I'll have to look into that. I have to figure out what exactly he's talking about. He hasn't had contact with us previously on this issue.
I'm sorry, I couldn't hear you.
We will research that issue and understand exactly what he's talking about. We haven't had previous contact with him about this issue.
Okay, thank you. Alicia Caspiridis.
Hello, can y'all hear me?
Yes.
I'm really bad with microphones. I'm Alicia Caspiridis. I'm the Executive Officer of the Home Builders Association. Speaking on behalf of the membership, I just wanted to thank Renee and the Public Works team for meeting with us and opening a public comment period. They did a great job of reviewing the information with us. We were unable to come to an agreement, though. Our primary concern with this ordinance is the added cost not only to the developers but to the housing as a whole. The changes to the requirements and the actual repair being made are exponentially more expensive than prior. Additional to the cost of the actual repair, the paperwork fees of the repair process add to that expense. Further requiring a builder to warrant 2 years poses not only a financial issue but an issue of sustainability for the ordinance as a whole. For example, if a builder is not in business for that entire 2-year time period, which is very standard in the housing industry, as most people know. It's our position that this ordinance, written as is, will cause more problems for streets than it will solve. We implore you to postpone this vote or vote this issue down pending more collaboration between our community and the staff to come to an agreeable and more effective solution.
Thank you for your comment. Anyone else? Is there anyone else that would like to make public comment on this item? Okay, with that, we'll close public comment. Mr. De La Garza?
No, I stand by any other questions.
Right.
Here, okay, so, Ernie, just expanding on what Councilman Pusley said, so has Development Services given us because when we discussed it earlier, we said Development Services is basically the one who issues a permit for this. Have we talked to them as to how often this could happen? I mean, I just can't see that there's going to be 20 driveways that are going to have to be impacted off of some utility reconnection, and I just don't see that. I'm just curious as to how this is going to happen. I mean, Alicia, I'm open-minded to also if you have a comment, but that's just what I'm trying to figure out. Obviously, I've always been a big supporter of the home builders. I'm the one, I don't know how many times, Peter can probably reiterate, I've said, what does it do to the cost of a rooftop? And so I'm asking an opinion of how does it impact the cost of a rooftop? Or because if it's for a developer, I don't see how a developer is going to have to redo utilities if they're developing property.
No, this was more specific to anytime anybody wants to access our right-of-way, they have to get a permit. And so once it becomes platted, it becomes city property, and they go from the the sidewalk line to sidewalk line, then technically they have to get a permit by ordinance. And that's what they said, are you going to go get an ordinance for everything? That was the comment I received. And the answer is, yes, you do, but like I said, within the ordinance, we can work with the customers to expedite one delivery depending on, so if they have a delivery for 15 driveways, well, we can put all that under one permit, but we do have early coordination. And that's one thing that I don't know that it was explained or maybe they didn't understand, is that if you have a situation where you're going to go and get a permit from the city, Public Works, and you bring to us all your information and your request, we are going to vet that request with the ordinance and see, okay, how can we make this more efficient and then something that we can expedite, right? So for example, if there's 24 driveways, well then we're going to say, okay, let's put all this under one permit. We'll have our right-of-way engineer who's leading the whole team get with their representative and then put together a plan and timeframes for how it's going to be something that is as per the ordinance, but at the same time meets their needs for expediency and construction. So I don't think that it's a true concern because you really have to dive into the entire ordinance to know that it's really not a big deal. We can work within the ordinance to appease their needs and make the request a little bit more tasteful.
Yeah, and Councilman, just to be a little more direct, this ordinance change is really for existing subdivisions, well-existing, not new subdivisions. The examples that we show in the presentation are those Ocean Drive, Laguna Shores Drive, where after 20 years or 30 years of waiting, we finally got a brand-new drive, only to have it cut several times, and you saw the picture. So it's for well-established neighborhoods. The intent here is not new construction, not greenfield development. So things like London Town and all these new subdivisions, this really is not written to address those.
Yeah,
It's the existing neighborhoods where taxpayers have spent, after 30 years, monies to repave a street or rebuild it, only to have a single entity come in and cut it. That's what we're trying to protect, is the taxpayer investment, who the same taxpayer that has waited decades for a new street, only to have it compromised by a single cut and one that's not appropriately repaired.
Okay, yeah, I think Crestmont, Allen Crest, I don't know how many times that street has been tore up for utilities. And that's a perfect example of all kinds of patchwork, and it's exasperated the pothole work because of the cut is not in the entire, from curb to curb, so to speak. Okay, thank you very much.
Okay.
exactly. And just one other thing, it was probably in the presentation, but this is what the 7 cities above us have done for, many, many years. It's appropriate street preservation methods. We know yesterday we ribbon cutted Cell Staples, a section by Ray High School. And this council, when I took this job, one of the top priorities, and it still is today, is streets. And so this is one more tool to protect taxpayer investment in streets, to make sure that if they have to be accessed, if they have to be cut, then they need to be paved to where it preserves the street for the many, many years that the street had prior to that cut. That's all this is. One more tool.
Thank you, Peter. I am going to go ahead and entertain a motion to approve item number 4.
I make the motion to approve this item.
Okay, we have a motion. Do we have a second?
Second.
We have a second. All
Mayor,
in
I'd like to
favor,
make,
say
Mayor,
aye.
I'd like to make an amendment to that motion to add under section 49-30, I'm sorry, appeals, give me a second. I missed it. I'm sorry, 49-40-6 under appeals to add paragraph 4. In further denial, if further denial is given, the applicant may thereafter file a written notice of appeal with the city council within 5 business days of receipt of the assistant city manager's written decision. The appeal will be held at city council at the 6th city council meeting within 20 business days of receipt of the written appeal. That's my motion to amend.
Okay, is there, I'm sorry?
Well, I'm the one that made the motion, and don't I have the right to not accept that amendment?
No, so we'll,
Was there a second to the amendment?
no, we're going to ask for a second.
I'll second the amendment.
You want to second the amendment?
Point of order, I believe that the author of the amendment has the authority to either accept or reject an amendment, according to Robert's
No.
Rules of Order.
Well, we have to vote on, no. I mean, we can make an amendment. An amendment can be made in a second. We just need to see if there's a vote, if there's approval on that. So
Hostile amendment can be attached to,
Sir?
a hostile amendment can be attached to a motion.
A hostile amendment?
That's new language.
Well, any amendment, I mean, we're not going to judge the amendment whether it's hostile or not, but it's an amendment.
Okay.
So it can be made.
Thank you.
Okay, so we have a motion, we have the original, we have an amendment to the motion, and now we have another amendment to the amended motion.
My amendment is to table this until we can come to another meeting with concurrence with everybody that's going to be impacted by this.
Has that not happened?
We did attempt and we did not get any responses. So it has happened, yes, Mayor.
I'd like to clarify that. You did get a response from me.
No, we're talking about,
Right.
we're talking about the community, we're talking about
We
the,
took
No,
it
no,
to the
but-
DSD TAC, which is the platform for these kind of amendments.
No, no,
or
no,
these
when-
kind of ordinances, and then we went to the body themselves. And the body themselves did not give us that our concerns, and then we would have come to you all with an amendment that met both needs, but that did not happen. So I can't speak to a disagreement if there was no feedback.
yeah.
Okay, I guess I was referring to the fact that the postponement was because I wanted to address the appeals process. So I actually interacted with you on that, based on that request.
Correct, but her question was, did we run
Right.
our ordinance
Right.
draft in draft form to industry before we brought it to this body?
Right, because the amendment to your amendment is because they need a seat at the table, and the understanding is they had a seat at the table.
Well, the only
So
reason
my-
I would
I want
agree with that,
clarity.
tabling it or postponing it, was to address the question that was brought up by David Loeb about whether or not it violates our charter with regards to a staff policy, the IDM versus a UDC. So we don't have an answer for that. But, I mean, is this considered an ordinance where we have a second reading?
Well,
Yes, right? So we have another bite at the apple at the next.
That is an ordinance. It's an ordinance.
Yeah.
Yes.
Not your motion.
But that, I was gonna-
No.
Second.
Okay, so you
That's a second to table?
Tabling it.
Okay.
Yeah, I'm gonna vote against it even if you get Gil's amendment.
So we have a response to your point. Janet has the feedback for the discrepancy that they're speaking to for the UDC and the IDM. But in addition to that, our entire bond program and our DSD processes use exactly the IDM and the UDC. So we're.
Just so you know, I did not vote
There's a
for the
ripple-
IDM.
There's a ripple effect there that we're speaking to.
And Ernie, just so you know, I did not vote for the IDM as it was written because I didn't think.
I understand completely,
Right.
sir, but that's how we're doing business as a city. And from where I sit, if you don't have a document that's a standalone document for criteria for engineering as a whole, then we're really getting into some issues there with how we do business as a city. That's just from where I stand in Public Works, so just like to put that out there.
Repeat that again.
For example, what I'm going to repeat is, he spoke to a UDC and an IDM discrepancy. The city, based on what Councilman Hernandez said, is that the IDM was not approved by City Council. The IDM is something that was in place when I came to the city as Public Works Director. My understanding is that the IDM is the design manual that the engineering department uses for holding our designers in the bond program, our designers in stormwater, our designers for utilities. Everything is in the IDM. So if you hold that document not relevant in this situation, then you're saying that document is not relevant in all situations. And so now you're opening what I would call a can of worms, because now we have to go and handle that issue. The reason that you had the UDC first was a standalone document was because it was there before the IDM was in place. And so we had a transition of all UDC information that went into the IDM to make it specific for city needs. So happens a lot in engineering. So for example, you have the federal METCD, and then you have the Texas METCD for traffic control. Well, the state of Texas takes the federal, makes it unique for the state's needs, and then adopts that as the state document, rather than using the federal document. In this case, we took the UDC and then adopted the IDM for specific city needs, because manholes are unique in the city, manhole covers are unique in the city, subgrade requirements are unique in the city. You may have sulfates, you may not have sulfates, you may have organics in the subgrade. All those things that are very technical in nature are addressed in the IDM. I understood that there was a very long process to develop that document, which engineering department was the editor-in-chief of. And so now everything that we make reference to for when a consultant can or cannot do something, we refer them to the IDM. If you make that null and void, well, then I have nothing to reference them, and then now we have dispute resolution in all aspects of business at the city of Corpus Christi when it relates to engineering.
Mayor.
Councilman Hernandez.
Okay, the problem that I had with the IDM is not so much the IDM itself, it's the fact that it is completely managed by staff, and there's no review process from the Planning Commission or the City Council. So what you have is a document from the IDM that is completely staff-run with no oversight from City Council or Planning Commission that supersedes the document that does have oversight from the Planning Commission and City Council. So what you're doing is you're having staff supersede the council in that process. So that is the question.
Right, yeah.
That is the question. Is it, you're basically putting in this ordinance a document that is staff-driven that supersedes a document that's council-driven.
Yeah, Councilman Miles has the answer to that question. Go ahead, Miles.
Well, the council has delegated that authority specifically to the city engineer, to issue that IDM.
Well, that's why I voted against it.
And
Yeah, so it says the city council approved an ordinance that said that the IDM will be managed by the engineer of record, the city engineer, and the city manager.
I understand that, but what we're talking about is the ordinance that says that, we delegated something to the engineer for documentation, for that particular item that can be changed without city approval, because it's been pre-approved, over a document that has to be approved by council.
Right, both were approved by council, so if the council wanted to, you could amend the language to say any other changes need to be approved by council and so on. Thank you. We're following council-approved authority, you know.
To the nth degree, yes, okay. You understand my opposition, thank you.
Yeah, we do, Councilman. And again, Mayor, this, to use Councilman Barrera's, statements in the past, this is a simple ordinance amendment to protect our streets.
Right.
We're doing a lot to fund our streets. We have a new program to get our neighborhood streets done 5 times faster. There's a lot we're doing for streets. This is just one more tool, and we've seen it. The reason we have this in front of you today is because we have evidence that it's happening. On Ocean Drive, after waiting 50 years, on Laguna Shore Drives, after waiting 30 years, the street gets cut and it doesn't get repaired to professional standards that every other Texas city is doing. This is a minor amendment to say, hey, if we're going to cut a brand-new street that's in great condition, we got to go curb to curb. It protects the longevity of the street and taxpayer money. That's the biggest thing. We're wasting taxpayer money by allowing what is happening today to continue. That's all this is about.
I don't disagree with what you're trying to do at all.
Right.
Yeah.
And a perfect example is what AT&T did on our street, Mackenzie Drive. When they put their manholes in, they were this much lower than, I'm sorry, I can't hear anybody anyway. So when they put their manholes in, they were 2 inches lower than the pavement all the way down Mackenzie, and had to be, and the city got blamed for that. So I don't have any problem with what you're doing. It's just, it seems like we've taken a 25-cent answer and put a $3 solution in for it. So
yeah, unfortunately, this ordinance has other amendments to the code that was dated, so the team thought it'd be better just to update the whole section. So it did get a little complicated in the presentation here and what's asked to be voted on, but the simplicity of it is that it's just that one single thing of street cut policies.
Right.
To beef them up, to save taxpayer money.
Okay. Okay, so the last amendment
Table.
was to table. And we do have a motion and we have a second.
Yes.
All in favor, say aye.
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 Any opposed, say no.
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 How many noes, ma'am?
We have Councilman Suckley, Councilman Barrera, myself, Councilman Pusley.
No, I voted for.
I'm sorry, Campos. And Councilman Roy.
I'm sorry, Campos, Roy, Suckley, and who else?
Councilman Suckley, Councilman Roy, Councilman Barrera, myself, and Councilwoman Campos to not table.
Okay, so that was just 4, no?
It's 5.
5, I'm sorry, okay. So it failed.
4. Yeah, 5.
Okay, Barrera also. Okay, that's what I missed.
So that motion fails.
Yes, ma'am.
So now we move on to,
Well, there was an amendment then.
Amendment now.
right,
To
which was,
amend, so the next thing we would handle would be the amendment of section 49-40-6 as read by, I forget who read it. I think you read it, right?
Hernandez.
I'll give you the copy when we're done.
Okay.
And,
So-
okay, Dan seconded
Do you need
it.
that read again, or does everybody remember what he wanted?
Can you refresh, just to make sure everybody knows what they're voting on?
This is adding a 4th paragraph to the appeals process, which goes from the director to the assistant city manager over the department. And the 4th one would be if further denial is given, the applicant may thereafter file a written notice of appeal with the city council within 5 business days of receipt of the assistant city manager's written decision. The appeal will be held at the city council meeting within 20 business days of receipt of the written appeal.
So this basically gives the appeals process to the council as opposed to the director.
No, it adds one more step, because
Well,
it still would go to the.
It adds
yeah.
a third layer.
That's
of
one more,
appeal.
one more appeals step in the process.
Right. Okay. Do we do, okay, we have a motion and a second?
Can I make a comment?
Yes.
I don't know why, I mean, I understand what we're trying to accomplish, but, I mean, I say all the time, I'm just a layman. You know, you've got, I joke around, and you've heard me say this, pardon me. So we have a banker, we've got a former medical billing clerk, you know, you have an insurance peddler, you know, you got another banker, you have a former soda fountain salesman, you know.
And naval officer.
You know, a geologist, what is it, Mike, what is it that you do? Anyway, my point is you have a bunch of laymen that's going to oversee a process that it should be handled by engineers that are professionally educated, that are hired by professionals that have the education and the experience to be able to make that decision. That just tells you where I'm voting. That's my opinion.
Thank you, Councilman.
I'd like to respond to that, Mayor, if I can. You just indicted our entire jury system. Because if you think about our jury system, the way it's just regular people making a decision on somebody's innocence or guilt, that are all laymen. So if you say that a layman is, that we're not educated enough and we're not smart enough to figure it out, then what are we voting on?
That's something completely different. If
Well,
you want to
but
talk about that,
but
we
it's
can
the
talk
same
about
thing.
that. It's not the same thing.
It's the same thing.
It's not the same thing, because you don't volunteer to be a jurist. You volunteer to decide, and it has to do with ego, and it has to do with, yeah, it does. Everybody's got an ego, they feel that they can make a difference. Anyway, this isn't part of the discussion.
All right,
But
we'll move
what I'm
on.
just saying is
So-
that I understand where you're
All
at, but
right.
I think you're wrong.
Call the
Okay,
question, please.
We're going to vote. All in favor, say aye.
Aye.
To the amendment, I'm sorry, to the amendment, to Councilman Hernandez's amendment, all in favor, say aye.
Aye.
Any opposed, say no.
No.
1, 2, 3, 4.
Opposed, raise your hand.
No
Yeah,
to
let's
the
take a
amendment.
roll call.
Okay, let's
Let's
do
take a
roll
roll call.
So for passage of the amendment, Councilmember Barrera,
No.
Campos,
No.
Hernandez,
Aye.
Hunter,
Aye.
Klein,
Yes.
Pesley,
Oh, I thought he said
Okay.
exactly.
Roy. I'm sorry, Roy? Yes. Okay, Suckley,
Yes.
Mayor Wahardo?
No.
Okay, the amendment passes, so then we just pass it as amended.
Okay.
So for passage of the, what is this, ordinance as amended?
All in favor, say aye.
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 Any opposed, say no. As
No.
amended. It's the same thing.
As amended, so we're just,
It's the same vote.
Mayor, we might want a roll call.
You want to,
I'm sorry, oh, roll call on that, okay. So for passage of the ordinance as amended, Councilmember Barrera,
Aye.
Campos,
No.
Hernandez,
Aye.
Hunter,
No.
Klein,
Yes.
Pesley, Roy, Suckley,
Yes.
Mayor Wahardo.
Here, I want to change mine to no.
Oh, you want to change yours to no, okay.
no.
All right, no, okay, and then Mayor Wahardo?
No.
Okay, it passes. So the ordinance passes as amended.
Thank you. All right, now we're going to go to consent agenda. We had pulled items number 11, 8, and 5, and we will start with the first one pulled, which is item number 11. Let's see, Councilman Hernandez, I believe you pulled this. And this is a motion awarding a facilities multiple award construction contract to Barcom Construction in the amount of $1,921,176 for gas department building upgrades. Your question or comment?
Okay, this is kind of the I guess, the original issue I had with the FMAC program, and I know not all council members are familiar with the FMAC program. I would recommend that engineering send that ordinance out to new members of the council so they understand what it is. And it's basically a pre-authorization for smaller projects less than 500,000, I believe.
Well, you can use it's under the JOC enabling legislation, and you can use it technically for any size, but staff has an authority to issue these task orders up to 500,000 without coming to council.
Okay, so it's kind of a pre-authorization for expenditures for construction projects that are less than $500,000 as written by the ordinance. So, however, I don't think there was any procedures in that ordinance, and you'll have to refresh my memory on it, with regards to what happens if you exceed that threshold. So when you have that, now we're looking at $1.9 million that would normally, if you had this come to council, would have to go through a procurement process, which we're not doing here for the sake of expediency, which I kind of, if you kind of look at this and the possibilities of what could happen, I'd ask that we relook at the FMAC ordinance to put procedures in place to address these kind of situations, so you're not putting us on the spot as a council to approve something that didn't go through a procurement process, or should I say a competitive procurement process. Because, then we'll have those issues going forward. So I'd ask that we put those processes in place so we don't come across this. Now, I'm not going to beat you up too much on this, because I understand that some things, unforeseen things happen. I guess you didn't expect to see mold, when you opened up the walls. But, I mean, this is kind of the situation, this is what we need to take a look at. So I ask that you bring back the FMAC, at the very least, to make sure everybody on council understands what that program is, and we can review it.
Okay, we can do that, Councilman. Yes, sir.
Thank you. And
Councilman Pesley.
Yeah, that's one concern that we need to look at, and I'm going to support this because we need to move forward. But I just want to say, Peter, this, if I were going to, pull an old saying out of the hat, I'd say this is no way to build a railroad. When we got into this project and we found out we had problems, we should have stopped and said, okay, we need to evaluate this facility from top to bottom. Because as I read the description of what was going on, and I didn't know whether we were fixing this or whether we should be calling out the bulldozers on this facility. And I talked to Bill yesterday at length and to Jeff, and I think we're going to end up with a good facility, but I'm just, I have to be concerned when I look at this process about whether at the end of this job, we're going to have what we thought we were going to have.
Right.
And
Yeah,
it's like building a car and then deciding you need to put a motor in it.
Yeah, this is a legacy project going back 7 years or so. So we have better teammates now and our business processes dealing with this.
But anyway, this should have been brought through the procurement process. It should have,
This is one it dates my time here, and and with new processes in place, this probably won't happen again.
Okay.
This type of a scenario.
Yeah.
Knowing what we know now, this would not have been a good candidate for the AFMAC program, and we would have just had a complete bid set and put this out full and open. But since we'd already started with this contractor and Bill had to move out of his facility, moving forward with the same contractor was the best way to get him back in. It would probably take us 3 months to put this on the street and get another contractor in, and of course, there's a little bit of a crapshoot to that. So this is not normal procedure. I agree.
But the bigger picture is we would have probably have assessed the entire building. I think the staff was timid back then and tried to incrementally fix it. We would have taken a bigger look to say, is it worth fixing? The question we asked at the American Bank Center is, should we demolish it or try to save it, type of thing,
Sure.
So that's what we'll do. That's what we're doing in the future. Yes, sir.
Okay, well, Mayor, if there's no other comments, I'd make a motion, we approve this item.
Okay. We have a motion and a second. Any further discussion? All in favor say aye.
Aye.
Any opposed say no. The motion carries. Item number 8, Ms. Campos, you pulled this one, and this is ordinance authorizing the creation of a Corpus Christi B Corporation project, which includes the expenditure of up to $1 million for the agreement with South Texas Military Housing. Yes, ma'am.
Thank you, Mayor. I made a few phone calls just to see if we didn't have to foot most of the bill. We're putting in the city $1 million, and I believe the port and city of, or Clayburgh, I think, or what, Kingsville?
Heather Hilbert, Assistant City Manager. Clayburgh County and the City of Kingsville and the port are putting in collectively $500,000, I believe.
Okay. So just, I was curious to see would we have been able to have obtained more money from the port. So I made a call, and basically I was told, well, that's all that the city, or that, not the city, but, well, yeah, the board, the B Board Advisory Committee submitted. So I'm just and I also ended up calling Mike Culbertson to see, because I think they were the ones that actually led this project. So I just wanted to make the statement of, let's, challenge other entities that can help with these type of projects, because I think they would have been able to have helped the city had we just asked. And that's all I was asking, can we do better? And speaking to Mike and speaking to one of the commissioners, yes, we could have done better, but it's already too late. And I just wanted to point that out, that we need to do a better job. So that was my statement.
Sure. Well, just some insight on that. So, this was brought forward. The South Texas Military Task Force actually did the initial work on this, brought it forward for approval. And we do have Preston here that could shed some light on that. But it was not that there was not a request there. This request was brought forward by the Military Task Force. They had already done the groundwork on it. And this is what was put together and brought forward for consideration.
And I respect that, but I think, again, it's already after the fact, but I want to, in the future, I hope that we, have at least more questions as to how the city comes to end up paying most of this money, when, we have the Port of Corpus Christi that could have, for sure, have helped us, a lot more than just what they're helping us now. So that was my statement. Thank you.
Great project. Motion to approve.
Okay, all in favor, say aye.
Aye.
Any opposed, say no.
No.
The motion carries. Oh, did you, no?
Anti-military.
For clarity, what just happened?
Councilmember Campos voted no, and of course, Mr. Hunter's absent, just on the vote on that.
Okay, thank you. And the last item pulled was item number 5, approval of the December 12th, 2023 regular meeting minutes. Councilman Klein.
Thank you, Mayor. I move approval of item number 5, but with the following comment. It's been the practice of the City Council to limit City Council members' comments to 10 minutes per item. I'd like to see that change from 10 minutes down to 3 minutes. We limit the public comment to 3 minutes. I think the City Council members should hold ourselves to the same 3-minute limit as well. Thank you.
Oh, man, I'm voting for that big time.
Okay.
It's a great suggestion.
Still waiting for a second.
Oh,
So second.
I beat you.
So is that
Kurt,
second for a
go ahead.
policy change? Is that, because we don't have a, right now Robert's
do
rules.
that with a simple motion. That's a policy change.
Yeah, so to limit or extend debate, so the Robert's rule says it's 10 minutes twice, right? So I was looking at Robert's rules, and to limit everyone's debate, it takes a 2/3 vote, and according to this, adopting a special rule by 2/3 vote after notice. So we have to,
Yeah, my motion was to approve with that comment.
with a comment. So we're not passing a policy, but you're making that comment. Okay.
What?
So he's just making a comment. He'd like to see that happen, correct?
Oh,
So
you're
that's
making a
notice, and
comment
it's-
or a suggestion.
That we bring
That-
it back in the future. No.
Yeah,
I mean,
yeah, not today, just that we have 3 minutes, okay.
Okay.
Comment accepted.
Okay, there you go, Mayor.
Okay, thank you, Councilman Klein.
Gil over here.
Talking about rolling.
Okay,
There's a second to the motion?
Yes, there were 2.
All right.
well, that
It was
wasn't
Michael and I.
Oh, that's right, Michael.
It's minutes, so what, he wants to add that to his statement?
He's just making a comment about it. I don't think we're adding it to the minutes, are we? Well, we would add them to the minutes for
So according to Robert's Rules of Order, you have to have a motion on the floor to have discussion. And so I made that motion and then offered that comment as discussion.
Is that still a motion
So I just took it as a motion to approve the minutes. We can discuss doing that, but there wasn't notice given, and otherwise, I don't think the council can just vote on that today, right? We'd have to have an item on a future agenda. So I don't know if we want to discuss it today. If the council is interested in adding that to a future agenda, I guess we could, through our usual processes, the mayor or 3 people, adding an item to an agenda.
Okay.
Okay, good. I'm on.
Okay,
But
thank you.
for now, I mean, there's a comment made, but what's before the council is the minutes approval.
Okay.
So there's a motion, a second to approve the minutes.
I move to approve the minutes from December 12th.
Oh, we didn't approve it.
Second.
Okay, all in favor, say aye.
Aye.
Any opposed, say no. The motion carries. Okay. We're going to go to public hearings, items 18 and 19. Item number 18 is a zoning case number 1123-01. Birdie Waldron LLC, located in District 4.
All right, thank you, Mayor. Good afternoon, Mayor and Council. Andrew Demas with Development Services, presenting to you zoning case 1123-01. The request is from the RS6 Single Family 6 District to the RS6 with a special permit.
Motion to approve as presented.
Great, we're going to go ahead and open public hearing with that. Is there anyone in the audience that would like to make comment on item number 18? Okay, there being no one, we'll close public hearing. Any further discussion? All in favor, say aye.
Aye.
Any opposed, say no. The motion carries. Item number 19 is a zoning case number 1123-02, Gulf Hudson Holdings and Patsy A. Brooks, located in District 1.
Thank you, Mayor. Again, for the record, Andrew Demas with Development Services. This request is from the FR Farm Rural District and IL Light Industrial District to the RMH Manufactured Home District.
I'd like to make a motion to approve.
Okay, we have a motion, we have a second. I'd like to open public comment. Is there anyone in the audience that would like to comment on item number 19? Come on up.
Afternoon, Mayor.
Good afternoon.
City Council. My name is Jorge Fernandez, 8233 Leopard. I am representing the Leopard Business Park, which we developed in 2016. We did a landscaping, everything in that area is being proposed for development. Also, I'm a manager of a mobile home park for on and off for 5 years. I see the need for housing, affordable housing for people, because they come into me, I get in the calls, and housing right now is just off the roof. This will open an avenue for people that can't afford this type of housing. Yes. That's all I have. Thank you.
Great.
Thank you.
Thank you so much. Anyone else? Would anyone else like to make comment on item number 19? Okay, we'll close public comment.
I have a quick question.
Yes, Mr. Presley.
Andrew, what are the, in looking at the plat, and I didn't read the ordinance, but what sort of protection boundaries do we have for the existing subdivision for this? I mean, they're not going to be able to place trailers right up against the property line, I assume.
That is correct. The UDC inherently requires buffer yards that will provide separation from adjoining property owners. It provides maximum densities. Fortunately, what the applicant is proposing is half of what the maximum potential density could be.
I saw that, yeah. Okay. Okay, very good. That's all I had. Thank you.
Okay, I'll go ahead and entertain a motion to approve item number 19.
There's a motion on the floor, Mayor, in a second.
Okay, sorry. Yes, sir. Councilman Klein.
Thank you. I think this is a great project. I'm very much in favor of trying to provide additional housing, low-income housing in particular. I have a real problem with the location of this. I just think it's too close to industry for human health. So I'm going to be voting no on this item. Thank you.
Okay. Any other comment or question? Okay, we have a motion and a second. All in favor, say aye.
Aye.
Any opposed, say no.
No.
We have 2 noes. Okay. And the motion carries. Section N, individual consideration items 20 through 22. Item number 20 is an ordinance authorizing a developer participation agreement with MPM Development LP to reimburse the developer an amount not to exceed $1,118,463.05 for the construction of a section of Oso Parkway related to the Oso Creek Corner subdivision located off of Yorktown Boulevard and southeast of Starry Road.
I move for approval.
Second.
Excuse me. Thank you. We have a motion, we have a second. I'm going to go ahead and
approving my
ask
district.
for public comment. Is there anyone in the audience that would like to comment on item number 20? Okay, there being no one, we'll close public comment. Do we have any further discussion? All in favor, say aye.
Aye.
Any opposed, say no. The motion carries. Item number 21 is an ordinance authorizing a developer participation agreement with Brazelton Development Company, Ltd.
Motion to approve.
My district.
That's why I did it.
Okay. We have a motion and we have a second. I'm going to open public comment. Is there anyone in the audience that would like to comment on item number 21? Okay, there being no one, we'll close public comment. All in favor, say aye.
Aye.
Any opposed, say no. Motion, Councilman Klein, no. Motion carries. Item number 22 is an ordinance designating 127.72 acres within the jurisdiction of the city of Corpus Christi as a tax increment financing district to be known as Reinvestment Zone Number 6, City of Corpus Christi, Texas, pursuant to petition by owners of Barisi Village properties.
Motion to approve.
Second.
Okay.
I tape measured it.
You did? Okay, before we vote on this, I'd like to just ask Heather if you could just delineate for us for clarity. Once this goes through, then there are certain what happens after this happens? After we create this, where do we go from there?
Sure. So this is the first reading of the creation ordinance. As it stands right now, we do not have the second reading of the creation ordinance scheduled yet. We are waiting for for commitment from either Del Mar and or Nueces County. At the point where we receive that commitment from them, we will bring it forward for second reading along with the interlocal agreement for their participation. After that, then there will need to be a developer agreement that will be negotiated between the city and the developer for performance within this. That will include more of the details, milestones, and any direction that is given by city council on what we would like to include in that. And then we will bring that forward for approval by city council. Then this is a reimbursement TERS, so all improvements based off of how that development agreement is written. We may reimburse in phases. We may reimburse for certain phases, certain assets, things like that. And then those reimbursements would not occur until the increment is built, so that there is that increment, the taxes are generated. And then it would have to be, the asset would have to be complete based off of how the development agreement is written. So this is on a reimbursement basis, so the developer does have to perform, the increment has to grow, has to create the income, and at that point, then the reimbursement would occur.
Okay. Okay, do we have any questions? Anybody have any questions or comments? Councilman Suckley?
Thank you, Mayor. Heather, at what point, speaking of milestones and things, if we approve this today, obviously we're going to be in a holding pattern until he gets with, the developer gets with the other taxing entities?
Exactly.
Will this first passage expire at some point, or will it just sit here indefinitely?
It would just sit there indefinitely.
Okay. Can we put some sort of a milestone on to be determined within a certain amount of time that we need to hear back? Just so that community has certainty as to what the path forward looks like, if any.
I think that's a really good idea.
An expiration on the first reading, is that what you're saying?
Excuse me.
We could offer
An expiration of the effectiveness of the first reading?
Yeah.
What are you thinking about? 180 days, 90 days, 30 days?
Like 90 days? In other words, 90 days for the other two entities to come on?
At least one.
At least
Or
one,
at
okay.
least one?
Thank you. I wanted to clarify that.
Yes.
Because technically, if we have, let's just say hypothetically, whatever your time frame is, and you have one
Yes.
that has it together and gets it in front of their
Yes.
board, then you're okay. You just
Is the
need to-
project viable with just two of the three?
I mean, that would be a question for the developer. I believe the developer is here. But as far as from the city's aspect, we would not want to create a TERS with just one taxing entity participating. We would need to have at least two taxing entities to participate. Otherwise,
Why
we would do.
say at least one?
Because the difference is that you have to wait and take it to the board so they can figure out at what percentage that they want to participate. So there's a lot of factors there, and ultimately the developer is the one that will look at, once those things are decided, and whether or not they can live with that.
Well, Mr.
Did I say
Blackburn.
that- did I say that
I mean,
right?
he's here. I would imagine he knows.
He's not going to know the answer until they get the percentages, because the percentages affect the money that go toward the TERS. Can't do that until you vote.
Okay, so yours is still
So
at
our
least
motion
one.
doesn't include that restriction already?
So as of right now, no. I mean, we could leave this at first. There is no requirement. The first reading does not expire. And so what we have said, though, is that we would not bring it back for second reading until we have at least one other taxing entity participating.
Okay.
And at the second reading, we would bring forward that interlocal agreement, because remember, with the TERS, the city creates the TERS, creates the zone, and then other taxing entities participate in that zone through an interlocal agreement, committing to pay an amount equal to the taxes generated at whatever their contribution percentage is. So they don't participate in they aren't part of the zone creation.
Right.
They participate through an interlocal agreement.
Can I just use an example of that?
Sure.
Because when you take a look at North Beach, if I remember when we created the TERS for North Beach, we got immediate response for one of them, but I think Delmar kind of held out, and I'm, if anybody's here from Delmar, I'm on record, I believe that's what the case was.
Yes.
And we proceeded with the TERS, and then Delmar later on came on board.
Yes.
And because they have the right at some point in time that if they decide no longer to participate, it works the other way too.
Exactly, and that's why, the city creates a zone and they participate through the interlocals, so they can cancel that interlocal at any time, yes.
Thank you.
Okay, I have a question, Mayor.
Councilman Pusley.
Okay, so Heather, given that, is there any parameters on if the developer does not acquire the financing or whatever's necessary to move this project forward? Does this have an expiration date on it?
It does not, but city council can cancel the developer agreement and could cancel the TERS. This is a developer requested TERS, petition
Okay.
TERS. And so if in a set amount of time, and that's something that, I assume we could include language in at the second reading that if the developer does not, or actually what would happen is that you would most likely put that in the development agreement, that if the developer does not perform by certain milestones, then basically that developer agreement is null and, is canceled or expires. And then the TERS itself can be dissolved at any time, especially if there is no commitments against that TERS. The TERS could be dissolved by city council.
Okay, thank you.
Mayor, can I make an amendment to my original motion? Should I just remake a new motion, or?
Why don't you resend and then
Okay.
yeah.
All right, well, I'll restate my motion to approve. It will be subject to, in the event that we approve the first reading today, that the first reading would expire after 90 days, if no further action for a second reading.
Okay. Okay, we have a motion and a second. All in favor, say aye.
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 Any opposed, say no.
No.
Okay, the motion carries. Thank you, Heather.
Sure.
Now we need to vote on the main motion.
On the main
Oh,
motion.
right.
On the what? As amended.
Oh, no, he just,
Since I made the motion
yeah.
first, I amended my.
Oh, you amended it then?
He did.
Yeah.
He did. So we went back, yeah. Okay. All right, we're good. Thank you,
Okay,
Heather.
thanks.
Okay. Next is item number 23 under briefings, and that is a briefing on changes to the Nueces County Appraisal
crap.
District.
I thought that was the amendment. Never mind. It's changed mine to aye.
So he made a motion, then he being Councilmember Second, restated it, including that provision.
So change mine to aye,
Okay,
because I thought it was the amendment.
okay.
All right, point of clarity here. Can you change, the motion was put on our agenda with specific
Yes.
language. Can that be modified without an amendment?
I think an amendment would be clearer myself if we had the motion to amend,
Yeah.
where you state that what you said it was 90 days at least. Oh, I'm sorry, it was, the first reading would expire after 90 days,
Yeah,
correct?
subject to the approval of that first reading.
Yes. So it would be clear if you would just amend it.
Oh, yeah. I'll go back and open. Yes, sir.
So I want to ask a question. I'm not, and Mike can probably answer this because I'm not familiar with county procedures. So when this comes forward to county, does the county do a one, is this a one vote for them?
Yes, there's no second readings at
So
council.
there's no second reading. So in your opinion, does 90 days, is that giving them enough time?
Should, yeah, plenty. Yeah.
Okay.
Okay. I'm gonna go back. I'm so sorry. It did not open public comment. So sorry. So we're gonna go ahead and open public comment on item number 22. Is there anyone in the audience that would like to speak? Sure, come on down. Why don't y'all come on down if you're gonna speak on this item? And just state your name and address prior to speaking, please.
Steve Moody, 6717 Faro Drive. I just wanted to say something, because I'm aware of the disparaging comments that were sent to y'all about the developer and some certain aspects of it. I did my due diligence today and reached out and contacted Steve Bridges, Steve May, the president of Bridgeview Capital. He told me that he has 2.3 times the amount of money needed to start this development, and he's quite excited to start it. So I wanted to put that out there to y'all and then on public record that I talked to the guy. There's plenty of capital there. So I just wanted to, if that was a concern. And then I also found out that the person who sent that message to you all has already talked and said that was his main concern, was the financing. So.
Thank you.
For what that's worth, I just want to put it out there, because I don't know if the county listens and knows what's on record, or Delmar, so.
Right.
All right, thank you.
Thank you. Yes, thank you, sir.
Mayor, can I just add to that for confidence for the council? We met with the investor that is partnering with Blackard. We met with them several times and face-to-face, so we've met them as well.
Okay. Councilman Roy, yeah.
I just want to add one more caveat to that, because, and I think Dan can speak to this, but from a banking perspective, in terms of you asked next steps, once we go through this process, then it's going to allow the developer to be able to have the tools to put everything together so that they can go out there and shore up their financing. So that was, because that was one of the things that was brought up, I think, in one of the texts, is that they were questioning whether or not they can get financing. But the way this works is that no bank's going to really allow, I shouldn't say no, there could be somewhere, but most banks aren't going to sit there and get to that process until they have something in black and white and understand the perimeters of the TERS and everything else.
Right. Okay. Thank you. Is there anyone else? Yes.
Hi, Jed Rollins, 401 Adriatic Parkway, McKinney, Texas. I just wanted to get some clarity. I've been working with Heather on putting the project financing plan together. I wasn't clear on what was being voted on. There was a project and financing plan that we had worked through originally that had gone to executive session, that we had had some counters that we'd worked through. Is that what was being voted on today, or, because that's important as we move forward with the county and Delmar?
No, what was actually presented today was per executive session, what was amended, what the county, what the council directed us to amend it to. And so it was, while the developer did come back with some counters on it, on the financing and then on the contingency piece that was asked to be removed from there, that was not something that was brought forward because we were following council direction to not include those. So it is something that if there is more interest in including that, we can bring that back at second reading and amend the project and financing plan. But what was brought forward by staff was the amended project and financing plan as directed by council in executive session.
Okay. Thank you. Okay, item number 23 is the briefing on changes to the Nueces County Appraisal District.
Thank you, Mayor and Council. Ryan Skrabarczyk, Director of Intergovernmental Relations for the city. Happy to be here today to talk about some of the pending changes that will be coming to the Nueces County Appraisal District. So if you can go to the first slide, please. So the Texas Legislature in the second special session passed Senate Bill 2, a comprehensive property tax reform bill, and created a new section of the tax code which applies to populous counties with that definition listed there. and that obviously does include Nueces County. You'll go to the second slide. Some of the changes that were included in the bill, but the ones we want to highlight for the council today are the ones listed below. First and foremost, creating 3 at-large publicly elected directors. Secondary, modifying the appointment process for the 5 appointed directors. Third, making the tax assessor collector a voting member in ex officio capacity. And 4, altering the number of directors. So if you can go to the next slide, please. So just for perspective, this is our current appointed Nueces County Appraisal District Board of Directors. And as you can see on the slide represented, the City of Corpus Christi has place 3 and 4 reserved. Those are direct appointments made by City Council, which you did here actually recently at the end of last calendar year. You can go to the next slide. So first, I want to talk about the 3 new publicly elected directors. These 3 seats will be at-large seats across the entire county and will be added to the Appraisal District Board in July of this year. The seats require a majority vote, meaning there are potentials for runoffs, and they are place-specific, meaning the individual, when they apply to be on the ballot, will choose place 1, 2, or 3. Nueces County has already posted the notice for deadline for application for the positions. I checked, it's actually on the Elections Department page as well as the county judges page. And applicants, and part of the reason why we're here presenting to you today is applicants for the ballot can apply from January 17th to February 16th, and so that window is opening here quickly. A public election for these positions will be held on May 4th, and the position will be seated on the Appraisal District Board July 1 of this year. You go to the next slide.
And Ryan, the 3 places, the 3 seats, they're the same geographic boundary, right? They're not like a council district per se?
It is it is the entire county. As I said, they're not divided up into districts. They are at large across the entire county.
Yes, sir.
Yes, sir. So some requirements and restrictions, and actually for the council in your board book is a fuller list of that complete list of eligibility requirements and restrictions, but they do need to be a 2-year resident of Nueces County, so it's a bit longer than standard. Not an employee of the taxing unit unless they're also a board member. They cannot have completed all or part of 5 terms on the Nueces County Appraisal District unless they were the tax assessor collector elected in that capacity. And then not more than the second degree of consanguinity or affinity of an individual who provides appraisals for compensation or represents property owners in those proceedings under the tax code. And as I stated, the full and complete list can be found on the county webpage and is in your board book. So you can go to the next slide. So we do also want to talk about something that's going to happen in this calendar year, and that will be the 5 new quote-unquote appointed directors to the appraisal district. At the end of this year, December 31st, all current 8 of the appointed directors that we started with you on slide 2, their terms will end. And this fall, City Council will participate in a nomination and ballot process with all of the other 22 taxing entities in the Nueces County Appraisal District that are eligible to cast votes for 5 spots as laid out by statute. Each taxing unit will be able to nominate 1 candidate per position, so that would be 5 from City Council and 5 from the other. Obviously, they can be the same person, but January 1st of 2025 will be the beginning of the term for those new 5 directors. Go to the next slide, please. So this goes into a little more detail on the process for these 5 appointed directors. October 1st, and let me clarify, these are deadlines. These are, I should mention, we have 2 folks from the appraisal district here, the director of administration and attorney from Nueces County Appraisal District, that can go into detail, but in talking and preparing for this presentation, they did assure me these are just deadlines. They fully expect, with this being a new process for the city and many of the other larger taxing entities, they'll back this process out to allow plenty of time for us to participate. But the deadlines are going to be October 1st. The chief appraiser will notify the city council its vote entitlement based on the prior year's certified tax levy. On October 15th, the council will approve our nominees by resolution and send those to the chief appraiser. 15 days later, the chief appraiser will return all eligible taxing entities a ballot with the nominated candidates, and then by the second open meeting, the council will then allocate our votes in our entitlement to those candidates or to the candidates of y'all's choosing. And then the chief appraiser will tally the votes and notify the entities and the appointees with sufficient votes. So you can go to the next slide. This is the formula laid out under statute that will help determine how entities that are eligible to cast votes will have their votes allocated. And this is an example for this calendar year based off of some numbers provided by the appraisal district. It's important to note that it's our tax levy in this formula. And so as an estimate provided by staff, we'll have a little over 1,000 votes of the total universe of 5,000 votes for these seats. Next slide. For some perspective on the 22 eligible entities that will be able to cast votes, they're listed in front of you, and these are ranked by 2023 tax levy revenue. And as I said, there'll be a total of 5,000 votes available for 2024. You can go to the next slide, please. So this just restates what I said earlier, but as in the statute, it now makes the county assessor collector an ex officio director on the board. It's important to note that he won't become official in that capacity until July 1 of this year. Next slide. Go back 2 slides, okay. One more, please. This slide. The list of the 22 entities, so yeah. Yes.
The goal of the legislature when they created central appraisal districts was to give the power to the school districts, and that's what they did.
Hey, Ryan?
Yes, sir.
Just, I may be jumping ahead, but just to better understand the voting and the ballot.
Mm-hmm.
So when we're giving back our ballot, your estimated number of votes that the city will get, based off the example, was 1,009. Can we?
1,009.
Can the council choose to or vote to allocate 1,009 votes on one candidate because we're really strong on one candidate?
That is my understanding. Yes.
So you can weight it however you want to weight it. Okay.
That's
it's going to be interesting. All right, thank you.
My thoughts exactly. But to some extent, this is a process that happens for 2 of the places on our current appraisal district. So it's not, it'll be new for us. It'll be new for the city. Okay, so I believe we were on slide 12. If you can go to slide 12, thank you. So just to give you a sense of where we are, the legislature did provide some transition language where we currently have 8 directors. This calendar year, we will go up to 12. That's, and then the following year and going forward, we will drop down to the statutorily required 9. And the next slide, please, will show you exactly how we get there. So this is a summary, and I understand that there's quite a bit on this slide. It is fairly complicated, and the far right column of 2025 and ongoing actually uses some terminology because over the succession of years, they will work to stagger the terms. So this could have been a much bigger graph, but I didn't think that would be entirely helpful. This shows you in the second column our current situation, in the middle column where we will, what we will be doing in 2024 and then 25 to give you a picture of where we're going. And I did want to be careful with the terms appointments because I know council's used to the sense of direct appointments, and so when we say appointed directors, it will be participating in this election-like process amongst the tax entities. And I believe that's it. I stand ready for questions, and of course we have some resources here available, some resource witnesses available.
Councilman, or does anyone have any questions? Councilman Klein.
Ryan, thanks for this presentation. I think adding 3 new board members, I guess it's board members elected by the public, I think is a good idea. I'm struggling with this myself. I hear a lot of comments from the public about how appraisals are conducted, why it is that home prices have been rising in Corpus Christi consistently, even though our population has not been rising. something besides supply and demand apparently is driving that. I don't know what that is exactly, but hopefully that these additional board members will be able to then maybe perhaps get to the bottom of that, but also then help communicate with the public about that as well. Thank you.
Yes, sir.
Any other comments or questions? Nope. Okay, Brian, thank you.
Thank you.
Okay, well, ladies and gentlemen, there being no further business, this meeting is, is not adjourned. Rebecca. Well, we have to fix one little, yeah, we do.
Mayor,
I'm sorry.
on item number 22, the TERS number 6 item, I just wanted to clarify procedurally. So we had started talking about, Councilmember Suckley had made an initial motion to approve that was seconded by Councilmember Hunter. And then there was some confusion about whether there was a motion to amend or not, right? Whether that was made. So it is clear, I think I did say that it is clear if a motion to amend was made. So Councilmember Pusley was asking if we could just go ahead and for the record state, as long as you're okay with that, that you made a motion to amend that ordinance to include the provision, that the first reading would expire right after 90 days if the second reading didn't occur. So are you okay with
Yes, ma'am.
recording it
Yes,
that
I am.
way? So then, Councilmember? No, he's good. He's good right now with, yeah, so.
Yep,
So
that's good.
I'm going to record that there was a motion to amend made, seconded by you, right, Mr. Hunter? And Councilmember Hernandez, you voted no on that
I
amendment,
voted no
right?
on the amendment.
Okay. But then, just for the record, can we vote on the ordinance as amended then, just right now? For item number 2 as amended?
Yeah, so
including
let's
that.
vote.
So just separately?
So we
Okay.
have my first and we have Councilman Hunter's.
Yes, you'll be yes, sir.
It's amended. All in favor, say aye.
Aye.
Any opposed, say no. The motion carries.
Okay, thank you very much. I appreciate that.
Thank you, Councilman Pusley. Yes. Okay. There being no further business, this meeting is adjourned.